both the delinquency cases, but also to represent the state in the child abuse and neglect cases. I worked for a state attorney who chose to do that, so I became intimately familiar with what we called our face cards, those face sheets of individuals who were young people who were first into the dependency system and then later into the delinquency system. You try to see them pathway. Many other jurisdictions, that was not the case. There were separate reports, separate dockets. We saw the benefit of having some continuity there. That was how we would be able to better extract the pathway we were following, the issues that families were facing. So, to amplify the point of why this kind of process was really so important, I actually want to tell a story that comes from a different field, one around risk assumption, just to amplify the point. There was a lecturer who was giving a lecture to a group of individuals who were like this. And to make the point of how we choose to assume risk, he asked for a volunteer from the audience to answer 3 hypothetical questions. These are the 3 questions that he asked. 1, assuming that I had a steel IV in front of me by this podium, about 15 feet long, 6 inches wide, 6 inches high, and I offer you $25 to walk across it, would you assume the risk of walking across that IV laying on the ground in front of the podium? Volunteer answered very quickly, sure, there's very little risk of doing that. So fine, hypothetical number 2. Assume that I have a similar IV, except now it's 30 feet wide, still 6 inches wide, 6 inches high, and now I stretch it across the gorge. And that gorge drops down to a bed of rocks, about 300 feet down. I'll offer you $50 to walk across the IV. Volunteer, very astute volunteer. He's way too interested to do that. So fine, answer my 3rd hypothetical. Assume that I got the same IV, same gorge, except I'm on one side of this gorge and you're on the other. Except this time I have your child on my side of the gorge, and I'm holding your child by the hand over the edge. And unless you come across this IV in some way to grab your child by the hand, I will drop your child into the edge. I'll offer you $100 to walk across this IV. Will you assume the risk? Volunteer pauses for a moment. Says, can I ask you a question? Sure, what's your question? Which one of my kids do you have? I tell the story, and the laughter tells me that either you were one of those children when you were younger, or you had one of those children as an adult. I tell the story because I think individually, when you think about that situation, we know that any parent, we know that any individual would do what they need to do to get across that IV, walk, shimmy, whatever it would be, to grab that child by the hand and pull them to safety. Now, in our systems, however, when you think about the way our systems operate, too often we don't make those extraordinary efforts to coordinate, to align our work in a way that prevents every child from falling to some negative outcome. Because we haven't figured a way to come together, child welfare, juvenile justice, education, mental health, to meet all the needs of these young people right now. So I tell the story because, again, individually we say we want what's best for children. But I think, not intentionally, perhaps for our benign neglect, we often don't do the systemic work that it takes to do this work well for each and every child. So today's presentation will start with some background information about what we know about effective practice in juvenile justice. This is some of the science behind it. It will move into some of the work around risk and protective factors, and then move into what we know about the multi-system youth known to both child welfare and juvenile justice. And then we'll reveal a practice model that we have developed at Georgetown University to try to address these issues. So that's the evolution of this session. And by the time we get done, it's my hope that you will see why this is an important audience for this work. Because if we don't have the kind of integrated systems work, if we don't have core structure, if we don't have core processes, the way we need them to be in place, we're not going to be as successful meeting the needs of these children. Okay, so I would argue that in today's world of juvenile justice, and when I say juvenile justice, I integrate in my head that you can't be talking about juvenile justice if you're not talking about all the related issues that these children present to come into our juvenile court system. But I think started a long time ago with kind of the child savers. We moved into the more legalistic stage of our juvenile justice development, if you recall. We then moved into a more punitive stage in response to the juvenile predator. And I think now we have a more data-driven, evidence-based approach as we look at juvenile justice in this country. I look at these 7 elements as being the platform for this work. Now, if any of you have done work for a long time in juvenile justice, you will quickly look here and say, Shay, I don't think prevention, early childhood prevention, and intervention is necessarily in our statutory mandate when it comes to working in the juvenile justice arena. That seems to go outside the scope of what we statutorily and perhaps our appropriations allow us to do. But I would argue that if I am a juvenile administrator, if I'm a presiding judge, if I'm a juvenile services director at the county or state level, I need to be thinking about every one of these 7 elements if I'm going to be successful in either preventing delinquency or then intervening when it does occur. So I may not be the person who's going to argue for the appropriation for my agency to do prevention in early childhood, but I may want to go to a county board of supervisors meeting, a county commission meeting, with my child welfare administrator, with my human services administrator, to say why it's so important for them to have services for kids on a preventive basis to stop their pathway into my system at a later point in time. I'll highlight one of these things. So these are the 7 elements. I'll go into them in very, very brief description because I want to move more into the multi-system model and development approach. These are examples of what I would say why these are smart investments, why juvenile court administrators, presiding judges need to be thinking about and advocating these things. How many of you are familiar with the Nurse-Family Partnership Program? It's pretty common around the country now. It was designed as a child abuse and neglect prevention program. Dr. David Olds designed the program that works with teen moms who are in disadvantaged circumstances. Many of them are drug involved, are giving birth as a teenager, and in very disadvantaged circumstances. It works to improve pregnancy outcomes and then early parenting skills for these parents. The results of this program were a 48% reduction in child abuse and neglect, which is what Olds was trying to do. But it also delayed second birth of the teen mom, a 59% reduction in arrest of the child, the infant, tracking longitudinally to age 15. And then a 67% reduction in behavioral and intellectual problems of the child at age 6. So we think about children ready to learn, ready to grow as they move from early childhood into elementary school and into middle school. These are significant indicators as well as fewer convictions of the child. So by the time the child was age 15, 72% fewer convictions. So if I'm a child welfare administrator, one of the things I'm thinking about is how do I have a strong partner? If I'm a juvenile justice administrator, how do I have a strong child welfare partner who's thinking about this type of programming? Because not only will it prevent abuse and neglect, which is good for my community, it's going to 15 years later cut off the cycle. It's going to cycle off the kids who otherwise would have come into my system. And then there's the cost savings benefit as well at the single level. Next stage of development. So I'm no longer in early childhood, but I am in the prevention of early intervention. And I use this particular program, civil citation, because it's spreading statewide in Florida. It is now being implemented on a pilot basis in a number of other states as well. What it recognizes really is that while we know that many youth should be diverted from the system, there should be diversion programs, we'll talk about that in a minute. We also know that for many kids, there's no need to even bring them into the formal juvenile justice system. That there could be kind of an accidental effect of that contact with the system that we can avoid. So in Miami, they piloted, now going statewide. This is a pre-arrest diversion. This is law enforcement being told that we can keep kids out of our system well before the arrest is actually occurring. So no arrest record, no formal appearance. They refer instead to other services in the community. This is their result. A 19% reduction in all juvenile arrests in the county. 83% successful completion rate, only 3% recidivist. So if you think, if you're familiar with your data, an 83% success how are we coordinating assessments? How are we coordinating case management from the agencies that lead into the court hearing? All of this is an important part of what we're doing. And then how do we put on the table what services that we have within our individual agencies and how they can be brought together as part of a case plan for the others. Juvenile detention reform, another key element. How are we keeping kids who are being detained currently from being detained when it's not necessary for public safety? So we have the Juvenile Detention Alternatives Initiative funded through the Casey Foundation. A number of you may be familiar with this. These are the results: 35% reduction in detention without an increase in offending prior to trial, 23% reduction in commitments to state custody, and 22% reduction in the number of youth of color in detention in JDDI sites. So this is about how we make decisions, subjective versus objective decisions, and this will relate to the crossover population. Because one of the things I will show in the research is that children who are arrested from child welfare placement have a much higher probability of being detained at the point of arrest. Similar offense, similar prior history, they have a higher probability. So detention reform is another one of these platform elements. Effective systems interventions. We know from the science we have now that we have a lot of proof programs at work. I'm sure you have heard in the family court, functional family therapy, multi-systemic therapy, cognitive behavioral therapy. We have science behind effective practice. We're not shooting in the dark anymore about what is an effective program. We have good science around the assessment of the other and matching that assessment to program. And then juvenile corrections. And what we've seen in the shift in the more evidence-based approach to juvenile corrections is keeping kids closer to home. I talk about the Missouri approach here. Local, smaller facilities, conditions of confinement being improved, educational services, health services, access to community resources, planning for reentry. We see this type of approach, which has significant reductions in recidivism, now being adopted in states like Ohio, New York, Pennsylvania, Connecticut, and now Florida, as well as the court buy-in that this type of approach can keep the community safe. These are the recidivism rates when Missouri was compared with these other states before they began adopting similar approaches. Missouri's recidivism rate was 9.6% compared to the other ones above us. Aftercare and parole. We see a lot of good things happening in many of our programs, residential programs. The question is, what are we doing to maintain and continue that good work as we plan for reentry and support kids during reentry? So we see now the science shows us as research, the overarching case management being a good approach in this regard. Again, I highlight these things because they ultimately relate to the multi-systems work. But these are the 7 prongs of what I see as the current platform we need to institute for an effective juvenile justice system in our counties and our states. What this leads to is a system redesign, a realignment, and a reinvestment in how we deliver our services. Classic example right now, state of Ohio. And you're from Ohio. Okay. State of Ohio. Your Ohio Department of Services had 1,800 youth in their facilities about 2.5 years ago. Today they have 600 youth in those facilities. By adopting a strong risk assessment instrument that was brought into by the judges, by reinvesting resources at the local level for courts to use to offer alternative services, they've seen this realignment of the population through that reinvestment without any increase in recidivism. So when you look at the recidivism rates in Ohio, you're not seeing them go up because these kids are being served closer to home. The arrest rates actually are down in Ohio as a result, I think, in part of more effective practices closer to them. So as we had this discussion, if you want to jump in with your perspective on what's happening in Ohio, that would be great. This is a partnership between the state and local communities. It's about capacity building. It's about regionalization. For too many years, we've seen kids arrested, put into placement 200 miles, 300 miles from their home community. That doesn't do us a lot of good in serving them in that facility and then transporting them back 300 miles without any of the connections that we needed to maintain while they're away, the pro-social connections that need to be in place. So all this really relates to the ecological model of juvenile justice, that children reside and live in these domains. The domains are their family, the community, the school, their peer group, and then their individual They simply did an inventory for all of these young people, middle school age, in the city of Rochester, on this point in time, what are the risks in their life that we know contribute to delinquency, and what level of protection exists. They found that these with 5 or more risk factors were high risk. So it may have been that they were failing in school. It may have been that they were abusing and neglected. It may have been an older sibling who was gaming involved. 5 or more risk factors were high risk for delinquency. Youth who had 5 or more risk factors and had 5 or fewer protective factors offended at almost 80%. So the lack of protection in the face of high risk leads to higher offending rates. High-risk youth, however, with 9 or more protective factors offended at a rate of just over 22%. So again, this is about evaluating a program, how much protection they interject in a child's life. You're simply saying that this particular young person, in the face of these risk factors, they had 9 or more protective factors, they offended at only 22%. You can do the math there. The presence of at least these 4 additional protective factors reduced offending rates by 75%. So the question presented to us is if we are looking at a child in child welfare, and they are removed from their homes, and they're brought into our system, they have certain risk factors in their life. They might have certain protective factors. In the way we manage those cases, are we enhancing protection, and are we reducing risk? And that's what I'll get into at this point with the presentation. By the way, that Austin Corley study found 2 factors, 2 risk factors, in the highest correlation to delinquency. One of them was gang involvement. So when a young person who may already be involved in some delinquent behavior joins a gang, the level of offending skyrockets. When they leave the gang, it goes back down almost to the level it was before. So the mere involvement in the gang is a very, very high risk factor for delinquency. And this other one is abuse and neglect, and that's what we'll focus on today. Just to give you a frame of those 7 elements I covered earlier, what I'm covering at this point starts with prevention, goes into integrated court systems, detention issues, and effective system intervention. So 4 of the 7 prongs of that platform are impacted through this presentation. So who are cross-over? We focus at our center on this middle definition. This top one is any young person who has experienced maltreatment, who then is engaged in some delinquent action, whether we know about it or not. It's an interesting population to learn more about. We learn about them through self-report information, for example. But our project at Georgetown is designed to change the way systems behave. So we focus on this definition. A crossover youth has had some level of system contact in both child welfare and juvenile justice. So they touch the child welfare system, they have a case manager, they have a case number, and now they also touch the juvenile justice system. An arrest is taking place. Some jurisdictions wait for the kids to be duly adjudicated. In child welfare, there would have been a petition, a finding of dependency, and an adjudication of dependency, and then an arrest and adjudication of delinquency. We don't wait that long in our work with Georgetown. We want to intervene at the moment a child involved in the child welfare system, whether they be voluntary services or involuntary services, touches the front door of the juvenile justice system. That is our moment where we can try to interrupt the trajectory leading into greater levels of involvement in the juvenile justice system. These are the pathways that we're following kids through. This first pathway, number 1, they have an open child welfare case, they're arrested, enter juvenile justice. 85% of the kids that we're seeing in our sites that we're working in are this pathway. The second pathway, they have an open child welfare case, the child welfare case is closed. The youth is then arrested, and as they're being processed through the arrest, it surfaces that there was a historic case in the child welfare system, and then they enter the juvenile justice system. Third, the youth is a victim of maltreatment, but undetected by the child welfare system. So it wasn't known that they were being abused and neglected. They're arrested. In the processing, the child discloses that they've been maltreated. It's investigated by child welfare, and so the reverse crossing over has occurred in this instance, but concurrent involvement at that point through a founding of abuse and neglect. And this fourth one is the youth who's arrested, put into a residential placement, and then released from the facility, but is abandoned by their family. There's no suitable placement to return to, referred to child welfare for placement. In some jurisdictions, Illinois did a statewide study, about 10% of the kids leaving juvenile corrections within 1 year will be in a residential placement in child welfare as part of their residential status. Okay. So, any questions quickly about or about the pathway. Anybody? Pretty clear stuff? So we have limited studies about the prevalence, but people say, well, how many kids cross over from child welfare to juvenile justice? In the studies that we can document somewhere between 7 and 30% of the child welfare youth also have a contact with the juvenile justice system. So while not a majority, it's important to note this. Just because you've been abused and neglected doesn't mean that you will inevitably cross over into the delinquency system. But a cohort of anywhere from 7 to 30% is a significant number of young people. And there have been some follow-up studies since I put this slide together out of state of Missouri and also Washington State, where there's also documentation on their population numbers and their prevalence. But we also see that it increases the probability of future delinquency and adult criminality overall by 29%. This is some of the work that Kathy Statsburg has done. Some more data about the increased likelihood. So there have been some studies that have looked at the characteristics of these young people, and that's what I want to talk about next, because that begins getting us to the point of who they are and what their experiences are in the system that may relate to this risk of protection. So, between 7 to 30% to cover that. What is their experience with the abuse and neglect in the system, the child welfare system? One of the things we see as a characteristic is that many of the young people are involved with persistent maltreatment. So the maltreatment begins when they are younger and continues into adolescence. When abuse and neglect occurs in early childhood and then ends in early childhood, we do not see a high correlation of those who cross over into the delinquency system. But one of the things that's not actually up here on the slide, so a study report from Mary Thornberry recently, showed that adolescents who experience maltreatment, adolescent maltreatment alone, was also highly correlated with cross-over. So even without persistent maltreatment, if we have an adolescent who's abused and neglected and comes into our system, we see that characteristic related to higher rates of cross-over. So it's something we want to talk about and look at. Why would adolescent maltreatment alone relate to higher rates of cross-over? What is the experience of an adolescent in your court system that may be different than a younger person who's maltreated? And maybe you'll see some of the characteristics as I go forward. Type of placement. So youth who are put into congregate placements cross over at a much higher rate. So if we look at this in gradations, the lowest rate of crossing over is for a young person who enters the child welfare system, is not removed from their home and receives services in their home, wraparound services. The second highest rate of crossing over occurs for youth who are removed from their home and placed with foster families. The third highest rate of crossing over is youth who are removed from their homes and placed with care. Those are bunched pretty close together. And then when you move to the congregate placement, it moves up very, very quickly. So the congregate placement clearly is a negative event in a young person's experience who's been abused and neglected and removed from their home. And we need to understand why that would happen. One of the things that happens often with the congregate placement is to create placement instability. So we see also the characteristics of young people who cross over is that child welfare experience is often in congregate placement and there's frequent movement. Some of the work that Dr. Denise Spurs did on this issue could document that every time a child moved, it increased slightly, but building over time, the probability that they would cross over into the delinquency system. Every move is associated with a slightly higher probability. The other thing that happens with those moves is that often those kids change school as well. So I want to relate this back to the risk of protection. If I imagine that I am a young person, I am in a home situation where I am being neglected, severely neglected, there is absolutely grounds for me to be removed. But in that home, I've got a network of friends that are pro-social. I'm going to school, I'm an A student. I've got relatives who I'm in touch with who are pro-social influences in my life as well. I'm now removed from my home. I'm put into a congregate placement, and I'm moved around a bit for the convenience of the system. So it's not that I'm acting out, I'm being moved. When I'm being moved, I'm not being kept in the same school. What has been introduced in my life? What's been introduced is risk. Right? So I am now at risk of educational failure. How many people have moved and changed schools? Show of hands. Okay. It's not an easy thing to do.
It's a peer issue. Are you going to make new friends? It's an academic program issue. Am I in tune with this academic approach that they're taking in my new school? Imagine that happens every 6 months. Imagine it happens every year. Chapin Hall studied this event and determined that every time a child in foster care moves placement and moves school, it sets them back 6 months academically in terms of their academic achievement. So if I think about risk and protection, I've taken a child away from pro-social peers, moved them into another school. I'm challenging them academically. If they begin to fail, what are they going to begin to do? They're going to begin to act out. When they begin to act out in our current school environment where scoring is important, where zero tolerance policies exist, these kids begin to gravitate perhaps to a negative peer environment as well. So now I've destabilized their life to the extent where if I think about that ecological model, school, family, peer group, I may have introduced risk into every one of those dimensions of this young person's life, where every one of them was pro-social and positive protection to begin with. So systemically, we need to look at what's happening in terms of the way we're managing these cases by our agencies, and how do our courts, how do our judges have the information they need to make sure we're not doing this for a young person. So this is the lineup: the type of placement, the placement instability, and the absence of positive attachments. Many of our agencies that we're working with in our different sites talk about the fact that they do have these contracts with providers. And the provider's contract may say something like, under your contract you are to transport the child to school. And they will have a group of kids in their group home. They'll take them to school at 8:30 in the morning. They will pick them up at 2:30. The child who says, I was on the lacrosse team. This is actually a true story out of Los Angeles. I was on the lacrosse team in my high school. And my group home provider said basically, I'm not obligated to go back to school and pick you up at 4:30 when you're done with lacrosse practice. So while you're staying here, you will get dropped off at 8:30, you will get picked up at 2:30. I've moved that child away from a positive pro-social attachment and a peer group, her peers on the lacrosse team, that could influence her in a positive way. Okay, so those are some of the experience there. The demographics, more likely to be male. If you think about where we place kids, you look at your placement rates. Are the placement rates higher for boys to go into group care than girls? What's happening along gender? But also increased likelihood of being female. Do we respond differently to girls when they act out? Those of you who may have experience with status offenders know that status offenders, if you're a girl, tend to have a more punitive disposition than if you're a boy. I think it's a matriarchal, patriarchal response to how we protect, and we protect sometimes by locking kids up for their own good. But this is another interesting one, more likely to be African American. Every one of our sites that we've worked with so far has shown that when they look at their data, of their crossover kids, they're more likely to be of color. How many of you have done work around disproportionality in your court systems? A few, okay. So you know that you probably have higher rates, disproportionate rates of kids of color in child welfare than represented in your broader population. You probably, if you've done work in juvenile justice, know that generally you have higher rates of disproportionality in juvenile justice than your broader population. This is what we know about the crossover population. Take whatever you have in child welfare and juvenile justice and know that it will be a higher percentage for kids who cross over. So something's happening in the communities in which we're working that is leading to kids of color crossing over at higher rates than the base population. Joe Ryan documented this in DuPage County, Illinois, Allegheny County, Pennsylvania, and Washington State. That the child welfare is feeding disproportionality into the juvenile justice system beyond the normal rated experiences. Yes? Well, what we are encouraging is that kind of interaction, that we want there to be a case management approach that is having juvenile justice and child welfare looking at this data and saying, what is the experience in our child welfare system that may be introducing risk, and are those factors, are those elements that are being experienced by children of color at higher rates than children not of color? So that's the interaction. So Job and Family Service in Ohio is the child welfare agency. And we want them, yes, right, no, Job and Family Services in Ohio, child welfare is what I'm talking about. Okay? Okay. And then we also see that children are younger at the age of their first arrest if they're a crossover youth than not. This also is informative in terms of what happens when they touch the front door of the juvenile justice system, and how our courts need to look at the data around what's happening to these young people. This is a study taken from Arizona back in 2004. What they found, looking at the juvenile justice population in the state, that only 1% of all diversion cases in Arizona in the juvenile justice system were kids who had child welfare history. Now, I don't know what your diversion rates are in your communities, but generally they're higher than 1%. So this is a very underrepresented population in diversion in Arizona. 7% of all probation cases in Arizona, when you look at their history, had a history in child welfare. But when you looked at kids who were placed in juvenile justice, their entire placement population, 42% of them had a child welfare history. So what's the story here? What's the story? Generally, if you are from the child welfare system and you get arrested, there's some perception or some factor that's coming into play in the court system that may be depriving them of the opportunity for diversion that other kids might have, more likely putting them on probation, but this actually was a representative figure. And then, once on probation, accelerating their movement into placement. So think about a young person who has been abused and neglected, the trauma of that, removed from their home, experienced a system the way I've described it this morning, not that every system is exactly that way, and then is put on probation. What are the chances that that young person will survive all the technical provisions of their probation order or end up in this population in placement? And that's what Arizona discovered. What we've discovered is that the young people who are brought into the system often are not offered diversion for a couple of reasons. So in our first 11 communities that we worked in, 7 of the prosecutors told us the following story. I don't allow young people into diversion who are in foster care because there's no one to sign for them, authorizing and indicating they will abide by all the conditions of the diversion agreement. Totally patently false. If parental rights have not been terminated, the parent can sign. The foster parent can sign. The worker can sign. Lots of people can sign. Or the benevolent prosecutor, and I was a prosecutor for 16 years, so I'm not mocking here. The benevolent prosecutor is saying, I'm really doing this child good because the chances they can abide by the conditions of diversion are so minimal, I'm saving them a violation of the diversion agreement. So instead of thinking about it from these terms, okay, so all of our kids when they're on diversion have to go down to the public park and do community service hours, or go to a hospital and volunteer in the hospital. Whatever the conditions are, they see these as difficult conditions for a youth in foster care to abide by. So instead of saying, well, if we're trying to hold a youth accountable, sit down with my administrative judge, sit down with my court administrator, sit down with my prosecutor and say, what are the conditions we could impose that they could satisfy? And those become the conditions of diversion, because it accomplishes what we want to accomplish, which is having these young people be held accountable for their behavior and also introducing them to some supportive services. So this is the Arizona experience. It's an experience we see in many of our communities. Obviously, 11 of the sites that we did work in to begin with, 7 of them had policies that absolutely eliminated any young person in foster care from going into a diversion program. Any questions about this? Do you think this is happening in your community? Maybe. I can tell you this. When we had our implementation teams and those 11 communities sit around a table and the prosecutor told them what their policies were, it was news to most of them. It was invisible. So my kid who's dropping into the gorge, systemically, was happening to these kids. They were not given that opportunity of that diversion. Okay, we covered the child welfare experiences, so I'm not going to repeat them. I do want to reiterate on the individual characteristics that many of them are not attending schools, they have attendance problems, they have special educational needs that may not have been identified, or if identified, not have been fulfilled. And they come from families that may have a history of mental illness, substance abuse, domestic violence, or criminal behavior. You go back to risk and protective factors, these are the risk factors that in any situation would likely lead to a higher probability that you would end up in the juvenile justice system. They're compounded when these are the underlying circumstances, and then we've introduced greater risk with the way systemically we've responded to these young people. The juvenile justice side, slightly less than half of the youth are charged with a violent offense, many of which are assaults. So that's one thing we get from people saying, well, these are pretty high-risk kids. You know, they've been traumatized, they've been abused and neglected, they're acting out. The vast majority of offenses that we see, even if they're violent offenses, are more minor offenses. Most of them are placement-based. Most of them are school referrals. If you look at on a scale of where they're coming from, they're on-the-street offenses that are occurring while they're in placement. So we're not seeing a lot of the armed robberies. We're not seeing a lot of home invasion cases coming from this population, at least when they're first touching our systems. But yet we are seeing them treated, for example, detained at higher rates. 1/4 to 1/2 were detained at the time of arrest. One of the sites that we're working with, Portland, Oregon. Anybody from Portland, Oregon? Or Oregon generally? One of the better sites in terms of working on detention reform. The Juvenile Services Director for Multnomah County, Portland, Oregon, was talking to me and said, you know, we really don't have a problem here about detention because we have a 90-bed facility, 34 kids are in our facility today. I said, fine. So have you looked at, of those 34 kids, how many of them are these crossover kids? So well, we don't look at that as a population indicator because we're under our population. And every day we look at how we can get kids out. 17 of the 34 were crossover kids. 17 of them. But they present challenges. Who's going to take them? So they bombed out of a foster family. They bombed out of a kinship placement. They bombed out of a congregate placement. And they don't want them back. So how do we case manage those cases differently? One judge from Colorado said, you know, when we have detention review, I order detention if there's no release, and then I order a 10-day report. But I realize on these cases, I need to put a fire under our agencies. So I now put this as a 2-day report. Any kid who came from an out-of-home placement in child welfare, 48 hours, you report back to me as to how you're going to get this kid out of detention, where otherwise, based upon the offense, based upon the prior history, they would not be detained. Okay. And then so the detention rates are high, and many have had prior contact, so they may be crossing over from child welfare to juvenile justice, but they may have an old juvenile justice case that came and went, was closed out from before. So that's not unusual that we see a 15-year-old crossing over when 13 had a petty theft or shoplifting, something like that in their prior history. Okay. So this is some work that's been done, recent articles that have been done. One study here from Missouri, and the author of the study is actually in the room. Anne is in the room, one of the co-authors of the study, I should say. And so this is a growing body of research, and this study over here from Missouri that Anne was involved in, and this one from Washington State and King County. So what are the long-term outcomes for these kids? Higher rates of substance abuse, higher rates of mental illness, higher rates of criminal involvement. And if I am a court administrator, if I'm an administrative judge, this last one is the one I'm scared the most about, which is if I don't do this work better, if I don't bring my agencies around the table and say, how do we make sure these kids don't fall through the cracks, I end up with them being the parents and the perpetrators of maltreatment down the road. So New York State actually did a study on this. They tracked their kids to age 25. It's hard on the paternal side, on the side with the boys, to track this accurately, but for the girls we can pretty much track. And 60% of the girls who followed this pathway from child welfare to juvenile justice and then to criminal justice had babies that were investigated with allegations of maltreatment by the time they were 25. 42% confirmed cases of child abuse and neglect. So we know the intergenerational phenomena around the cycle of abuse and neglect and delinquency and involvement in the criminal justice system. We have an opportunity to interrupt that, and that's what we've done with our work in juvenile justice. I'm going to skip over these for the sake of time, but these are the critical issues that we think we need to address, and these are the implications for the system, which I will not skip over. Interagency collaboration is not an option for us to do better. So when we work with our sites, we work with the court administrator, we work with the presiding judge in the family court, and we say, you need to work with us, we need to convene the child welfare director, the juvenile justice director, the superintendent of schools. I know this can get complicated. Some of our counties have 25 school systems. So the largest school systems need to be brought to the table. The director of mental health the director of substance abuse treatment. All the players who would play a role in the underlying issues that these young people face need to be brought to the table. The collaboration also includes the public defender, the prosecutor, the lawyers in the dependency system who represent the children's interests and the family's interests, the court appointed special advocates. We look at implementation teams that are anywhere from 15 to 25 people strong. But there is a triad in this group, and that triad is the presiding judge and the court administrator, the child welfare director, and the juvenile justice director. Without those three players, we will not see the kind of system alignment and systems integration that needs to take place to do better by these kids. All right, so let me talk briefly about the goals and principles and elements. These are our goals. One, to reduce the number of youth placed in out-of-home care. So we clearly see this as a precipitating event, that once we remove a child, the rates of crossover increase at a higher level. One of the things we know about child welfare practice in America today is that the child welfare systems are looking at ways to reduce out-of-home placement and to serve kids better with wraparound services. Two, the reduction in the use of congregate care. If we are going to remove a child, everything possible must be done to have that child be with either family, kin, or a foster family, rather than a group placement. Three, the reduction in disproportionate representation of children of color, particularly in the crossover population. So a few of you indicated you do work in this area. You know how hard it is, not just to reduce the raw numbers, but to actually reduce the disproportionate representation in either child welfare or juvenile justice. If you think about this mathematically, if the crossover population is inherently disproportionate to the disproportionate representation in child welfare and juvenile justice to start with, if you reduce crossing over, you will also reduce not only the raw numbers, you will reduce the disproportionate representation. It's kind of built into the formula. And then last, reduce the number of youth crossing over, period, or becoming duly adjudicated. Those are kind of our four goals that we put around this work, but there are a lot of supporting goals. Practice goals: reduce the use of pre-adjudication detention, increase the use of diversion, reduce the number of youth re-entering child welfare from juvenile justice placements, improve pro-social bonds, and reduce recidivism. I mean, if you think about the characteristics that I just related to you, you can understand why these would be our practice goals, and these would be our process goals. Increase interagency sharing of information. You know, it's one thing to say, bring these people to the table, but they have to come to the table with their data. They have to come to the table with the case information on what's happening with these young people and be able to share it. Increase the use of joint assessment and increase the inclusion of youth in family voice and decision making. Our best child welfare practice in this country today is child welfare practice that respects the strengths that families bring to this work and includes their voice in how we develop our case plans, as well as the young people themselves. So why did we pick a practice model? We picked the practice model because it actually explicitly links the agency's policies and practices with its mission, its vision, and its core values. It describes specifically the outcomes we are trying to achieve, both our overarching goals and our intermediate practice and process goals. It is prescriptive in what our agency staff are supposed to do, as well as our court staff. And this is something often that's missing from what I was in a meeting yesterday in Minnesota. And the child welfare director said, so we're launching this practice model and we're doing some good work. And we had our two caseworkers come together, probation worker, child welfare caseworker, and they kind of sat there and they didn't really know what they were supposed to do. You know, they kind of could feel their way through it. They talked about the case, but there wasn't something explicit they had designed that was expected. The county sitting next to them, another county in Minnesota, said, no, when our caseworkers come together, we gave them a checklist of 7 things they're supposed to share and talk about during the course of that joint case management meeting. Very explicit as to what's supposed to happen, very prescriptive. So it also includes the practice activities and rationale that form from case management opening to closing, as well as evidence-based approaches, promising practices, and perhaps most important, approaches that are believed to be effective through practice-based experience. So we talk a lot about evidence-based programs. We're looking at something beyond just evidence-based programs. We're looking at what we know from our practice in our local communities is also effective that we have data around. These are our principles. I'm going to go through them very fast. We serve every child individually. We respect the role of family, that children should be in a family environment, that youth and families have strengths that need to be supported, that we need to ensure authentic, intentional, and meaningful involvement of youth and families. I've sat in on family group conferences, a new approach being used in many child welfare and juvenile justice systems. This is a practice where we bring families around the table with the professional staff. It's a conversation about what's a better way to get to a good outcome for your young person. I've watched this unfold where the professional staff talk for about 25 minutes, then they turn to the parent and say, so do you have anything you'd like to add? That's not family engagement. That's not an authentic, intentional, and meaningful involvement of the family. It's from the very beginning the family members having a role in the conversation, helping you to identify the strengths, the weaknesses, the opportunities they have to be successful with their young people when our systems are no longer involved. We use an integrated approach. We make sure there's fair and equitable treatment. This gets to the racial disproportionality issues. We make sure our workforce has the skills that are needed. So I give you an example of a family group conference where at the end of the session someone turned to the parent and said, do you have anything to add? That's about workforce efficacy. That's about training staff and then doing quality assurance around the work of staff to make sure they have the skills. Many of the probation directors that I work with say, look, this is all good stuff, Shay, but this isn't the job description that I use to hire the staff that we employ in our agency. Our folks are more accountability based. They're more looking at the terms and conditions of probation, the terms and conditions of parole, the safety in a facility. They're not trained around youth development. They're not trained around family engagement and motivational interviewing and how to get families excited about what they can do to make a difference in their child's life. So one of the things that we talk about is making sure that we don't have unreasonable expectations of our staff. That while we're adopting these policies, we're also saying we're going to train our staff up on how to do these things well. Give them the tools that they need. Another example from Ohio, how to enhance aftercare, particularly for kids in the child welfare system who have been placed residentially in juvenile justice, who now will go back to a home community. Who's going to be there to receive them? Who understands the challenges and issues that young person's facing? So the director of parole in Ohio said, I'm going to buy laptops for every one of my parole officers. I'm going to put an air card on every one of the laptops, and I will expect them to go and visit with family. The family members we've identified that can be positive additions to this child's case plan, go to their homes, sit with them and put them on Skype, and connect them to the young person while they're still in residential treatment. Go to the school where this young person will be returning and have a school counselor talk with this young person. How many times do we hear about a kid goes away for a year? They're frozen in our heads that they're coming back exactly the way they left us. The problem kid I don't want back in my school. How do we use the technology and give the tools that are needed to our workforce? How do we make sure we've got the data and evidence? I talked to you about disproportionality. I said that in our crossover work we see higher rates for kids of color. You need data to be able to reveal that fact. Your child welfare agency, your juvenile justice agency, your courts needs to have reliable data and evidence about what's going on with this population to understand whether what's happening in your community is the same as is happening in these other communities that I've highlighted in the research today. And when an out-of-home placement is necessary, time-limited, least restrictive environment with a focus on permanency. What is going to be the permanency plan for these young people that we have moving forward? So this is our practice model. It works in a linear fashion. It goes through a process where we imagine a young person who's in child welfare, actively involved either in a voluntary status or involuntary status, and then crosses over into juvenile justice. And I'll talk briefly about every one of these three phases and 5 practice elements before we open it up for questions. So phase 1 is arrest, identification, and detention. We want protocols that allow how client information can be searched to identify crossover youth. So in New York City, there was a research project done that determined this disproportionate overrepresentation of crossover kids in the detention population. They were flying by invisibly. They were by stealth. No one really knew who they were. They didn't self-reveal that they were in foster care when they were arrested. They didn't say, I live with my grandmother because I've been removed from my parents. They just got arrested, they give an address, I live with my grandmother, and that was the end of the discussion. So we need to make sure that our court, our child welfare agency, and our juvenile justice agency have set up protocols that allow them to search databases so that when an arrest takes place in your county, that information, that triggers a search to see if that young person is known to the child welfare system. And if that child is known, then what's going to happen as a result? But this is not an easy task. How many of you think you have memorandums of agreement in your counties that allow the search of databases that child welfare and juvenile justice can inform each other whether a child is known to the other system? Just show of hands if you have that already. A couple of you raised your hands. So this is our first body of work. How do we set up an agreement that allows the search? Because if we don't do that database search, we're not going to know these kids exist until when? Until they show up in one of your courtrooms and the judge looks at the kid and says, "Don't I know you? Or didn't I have your brother here? This name's familiar. Didn't I have your brother here?" Or they look at the mom and say, "Wasn't another sibling in my court a couple years ago?" So we can't do it by happenstance, right? We have to make sure that there's some intentional search that takes place. A memorandum of agreement that describes the ability of the child welfare and juvenile justice staff not just to know that the other has a kid in their system, but to share information about that child and about that family. They must include information sharing of education and behavioral health information, if not in the original agreement, in at least some side agreements that take place. So another body of work that when we work with our communities, we're saying to them, to the presiding judge, to the court administrator, to the two agency heads, are we going to be able to sign an MOU or an MOA that's going to allow the sharing of information so that when we know there's crossover, the two caseworkers can call each other and actually share information with each other. That if your state law or your local practice is one around confidentiality, how do we work through that? Not around it. How do we work through it? So are there exceptions in your state code in certain situations where you can share with juvenile justice or child welfare, but you can't share with others? To step by step work through what can and cannot be shared and enter into an agreement. And then take on the educational issues and the behavioral health information. Again, under HIPAA, under FERPA, what can appropriately be shared, and if it can't be shared by regulation, then do you get a court order to share information? Do you seek a parental waiver to share information? But with some intentionality, we're talking about the need to share information and setting up a mechanism to do it. Take a look across your systems around the screening instruments that you use. So what screening instruments being used in juvenile justice to screen for detention, to screen at intake, and share that information with your sister agencies. Know what your child welfare agency is doing around your safety assessment. What is contained in these assessments? What kind of information can be used? This is all in the front end of the system around the detention and intake to help better inform your caseworkers around what might be an appropriate alternative to detention, maybe to prosecution, use of diversion, things along those lines. This is all in this arrest, identification, and detention area. If you think about what happens with these kids, where we kind of push them into the system, don't allow them to have diversion, this is an appropriate first step. And then the decision making around charging. Conduct diversion meetings and pursue strategies to reduce crossing over into the juvenile justice system. This is a typical scenario. This is one of our judges in one of our sites. I keep getting kids from this particular provider. This one provider in our child welfare system sends me 80% of our crossover kids. So they sat down with their child welfare director, sat down with their law enforcement police chief, sat down with their prosecutor's office and said, what can we do to change this picture? That court was a driving force in saying, when we get a call from that provider, police will respond with the job of de-escalating the behavior rather than necessarily removing the child, and they will be accompanied by a mobile crisis response unit from our mental health agency. So instead of the easy out from that one provider, where the provider was saying, these kids are tough, they're hard, they're acting out, they pushed a worker, they damaged property, I want them out of my group home. The answer instead was, if you want to be a provider in our county from this point forward, we will see law enforcement and mobile crisis response work with you to de-escalate behavior to keep the child in the placement. Because if we can keep the child in the placement, we avoid the instability, we avoid the potential for change in school, and we avoid the kind of disruption in their life, the introduction of those additional risk factors. And then in one of our sites, actually here in Central Florida, they changed their contracting. They told the provider that if you agree to accept a child, and tell me how this would float with your judges, if you agree to accept a child for certain diagnosed behavior, you cannot eject them from the placement for exhibiting that behavior. You can prosecute them. If your worker says, this kid hit me, I want to prosecute him for a simple battery, you can prosecute them for vandalism, but you can't eject them for acting out exactly the way you knew they would act out when you agreed to treat them. And then compounding that, they would say, fine, and then also we'll will work with law enforcement. Miami-Dade County, Florida trained every one of their police officers in crisis intervention, how to de-escalate these situations. So this is all about this diversion decision, the intake decision, and how we change the behavior. Phase 2, which is practice area 3, is the ongoing case assignment, assessment, and planning. So upon notification of a new crossover youth case, the newly assigned probation officer immediately makes contact with the assigned social worker. Within 3 to 5 days, the level of contact may happen pre or post adjudication. That is in there because sometimes kids plea out at their initial first appearance before the workers have even had a chance to make contact in a detention situation. And then to have those caseworkers know exactly what's expected of them in terms of making contact. When we were surveying some of the practices prior to our practice model going into effect, this is some of what we'd hear. Well, we have a regulation. We must make contact before we go to court. Well, how did you make contact? Well, I left them a voicemail. And in the voicemail, I told them I've got Johnny on a docket in 2 days, and I need to know more about the history and child welfare. They then, the child welfare caseworker, called me back. They left me a voicemail. And the voicemail was, this is what I know about Johnny. And that was our contact. This is not what we're talking about. We're talking about clearly delineated expectations that ultimately your judges in your courts will have a bench card in front of them. And that bench card will say, if I've got a child in front of me who had a child welfare history, who's crossed over into juvenile justice, is this crossover youth, these are the 10 things, the 7 things, whatever it is in your county, that I will expect from the caseworkers coming into my court. My court docket will have a color-coded jacket. So when I see a yellow jacket coming to the bench, I know it's a crossover case. I know that's one of my bench cards that I'm going to use for that child. So much of this is just about the agencies. It's for me, ultimately, how the court administrator and the presiding judge enforce this. Make sure it happens. They are the ultimate quality assurance about the things I'm talking about today. Yes, I get it. A child welfare director, a juvenile justice director is responsible for their staff. They're responsible for doing oversight to make sure these practices are actually conducted. But at the end of the day, if I'm a family member, if I'm coming into your court administrator, your judge, is responsible to make sure my experience is in line with good practice. And that's what we're trying to achieve with this crossover youth practice model. That as much as the agency heads need to monitor, it's the judge ultimately that wants to make sure the family's experience, the youth's experience, is as positive as possible. Okay, this next one is about the assessment tools. Inventorying the assessment tools that are used by your child welfare agency, your juvenile justice agency, your educational agency, your mental health agency, your substance abuse agency. If you think of, once you inventory this and you see how many times we assess the young people and their families who come before us that are multi-system involved, you'll understand why it's so important to do this. Where is there redundancy? Is there some assessment step that we can streamline? Even knowing how many times we assess and how frequently will help us understand better the demands we put on a family. So on Monday they're being assessed at the school. On Thursday they're being assessed by child welfare. The next Wednesday they're being assessed by juvenile justice. We need to revisit that. It's not that these assessments are important. In some instances they're mandated. But we can think about the sequencing. One of our psychiatrists in one of our sites said that after looking at the sequencing and the frequency, he actually believed that there was a taint around the validity of the assessments themselves. That at some point in time we burn out a young person or burn out a parent with over-assessing them when we don't leave enough time in between the actual assessment process. So we want this to be a assessment inventory, and then we want there to be a discussion, in this case management design, of what assessment information do we have and how do we use that together to present to our court one type of consolidated assessment of the youth and family. I'm not talking about a unified assessment tool. I'm talking about taking all of the assessments and the caseworkers around the table, whatever methodology you use, a multidisciplinary team, a family group conference, family team meeting, to use them and then present to the court. If it's a one judge, one family, a unified family court, that one judge, information that pertains to both the juvenile justice and the child welfare case. Or, conversely, if there's 2 judges, we have a split docket, one dependency, one delinquency, that the judges are getting consistent information. That a family member is not going into court and is not listening to a recommendation going to the delinquency judge, that it very well could be inconsistent with the recommendations that are going to the other judge. And that's what happens very, very often. Inconsistent recommendations and the family members are confused as exactly who's their lead worker, what they're supposed to do. Any questions about that or any thoughts about that? Because I think that's a challenge. I mean, I'm assuming that a lot of what I'm saying to you, as we're kind of rushed through this, is not necessarily in your minds, yeah, he can say that real easily. I'm not sure how easy it is for us to do. Now, how many of you have a unified family court model in your county? One judge, one family model in your county. Okay. Dedicated docket for specialized cases in your county. Family drug court, things like that. Okay. So this is what I'm talking about, for this population, revisiting how they fit into your court structure. We look at a variety of court models as acceptable. The main thing for us is that the experience of the child, of the family, is a coherent one. And right now, for crossover kids in many places, it does not have that coherence. Okay, this is a consolidated joint assessment I just talked about, the integrated case plan that I also just talked about. Okay, so this is phase 2, practice area 3, the family role in the process, guiding the process. How many of you use family group conferencing in your counties? How many use family team meetings as a variation of family group conferences? So this is about the way the families are sitting at the table, taking ownership up and helping to develop the case plans that are going forward to the court. And then all jurisdictions making a commitment to reduce the use of group care, including residential institution, for these crossover youth. Phase 2, practice area 4, deals with making a determination as to which agency will take the lead. So some counties push back on this and they say, we don't want one agency to take the lead. We want both agencies to maintain responsibility when the crossover occurs. When I was in the state attorney's office in Miami, we would generally do one of these. It was, oh, they crossed over to juvenile justice, you take the case now. Or you have more resources in child welfare, even though they crossed over, you take the case. So what we're asking is there to be some intentional decision. We believe that someone needs to be the lead, and that needs to happen without the other agency walking away from the table. That they both maintain responsibility. So we do this in a sense by going to this next bullet, which is that even if someone's taking the lead in providing services, kind of pulling together all the services, we want the two caseworkers to have contact at a minimum on a monthly basis and ongoing case management. So some of our workers say, well, that's not important. If nothing's happening, if we're not hearing about anything bad, then we know we're okay. Why would we have to talk on a monthly basis? And it's really to give context. Something may be happening. A probation officer tells us, you know what, the kid's starting to skip school a little bit. I'm looking at maybe tooling them up a bit, maybe looking at a technical violation on probation. If they can have that monthly call, or at a minimum monthly, and the child welfare worker can say, let me tell you what just happened. Something happened on the child welfare side of this case. A younger sibling who had been in the home now has also been removed. A grandparent died. Something that may be peculiar on the child welfare side that wouldn't have come up in the case management on the probation side is revealed in this conversation that may help them manage the event in a different way. So we want to see that ongoing contact. Frequency of formal gatherings. How many in child welfare in your courts say that your child welfare agency will convene about monthly or quarterly or every 6 months on a regular basis, pull together a family team meeting of some kind just to update in child welfare how the case is going? Show of hands. Not many. Okay. What we want to do is to have you at least review the frequency of the formal gatherings and how that's used to review the progress, and that should be dependent on the case dynamics. So prior to court hearings, we believe there should be some type of meeting between the two workers and the youth and family about what's about to happen in this court hearing. Significant change in family dynamics. The younger siblings are returned to the family. The sibling who's on probation has not been returned. I visited with a youth in a correctional facility. He was about to be released on parole. And he said, my two younger siblings both were returned home last month. And so I'm thinking I'm going home. When I get released, I get to go to my home. Caseworkers, that wasn't the plan. The plan was they were going to step him down into a group home for about 3 months and make sure the family was ready for him to come home. That requires the kind of meeting I'm talking about. It requires everyone to come around the table and explain to that young person that the plan is to get you home. But you can't expect to go home at this point. It would be too much pressure on your family to have everyone coming back at the same time. So we'll step you down. Let's talk with you about where we step you down to. So maybe we don't put you in a group home. Is there another type of placement you can go to that isn't in that group environment? A family member that could possibly take you. So we look at all these things as possibly being reasons to convene this type of meeting, including when a family member says, there's some stuff going on we need to talk about. And so can we have this type of family group conference or family team meeting? So this is the integrated assessment process. Phase 3, practice area 5. So this is the final phase of the practice model. And it really focuses on kids that are having their cases closed out. The crossover population obviously is an older population than the general population in child welfare. But these are kids that have crossed over, so they have to be in the age bracket of at least 10 to 17 or 12 to 17 to be eligible for juvenile delinquency petitioning in your jurisdiction. I know jurisdictions are different in terms of ages. So we know we're going to have an older population. We need to think about permanency in terms of reunification, in terms of adoption, but we also need to think about what's going to happen as these kids age out of the system and how the two agencies will work together to support the young person in aging out. So we look at permanency planning as a key element. Permanency planning obviously takes place in child welfare all the time. If you are eligible for 4E in your jurisdiction on the juvenile justice side, you do some form of permanency planning as well. This is required in order to get the funding. You have to have certain case management approaches. The court has to have certain findings in order to maintain eligibility in juvenile justice for 4E funding. What we want to see is this kind of permanency planning across the board. That for these kids where there are so many issues going on, all the characteristics that I talked about earlier in the research, we think there needs to be a permanency plan for every one of them. Whether they're aging out, whether they're going back home, whether they're going to live with a family member, we need a permanency plan for that young person. We focused on one tool in particular called a permanency pact. And it's for young people to have agreements with meaningful adults in their lives, pro-social adults, on the roles that they will play when they age out of the system or when they go back home. So you think about case management in your courts. Your caseworkers probably are calling up people saying, Johnny's going to be released from a facility, coming back to the community. He's going to need some support. Can you help him out? In good case management, we're identifying people like that, right? And we're saying what role they might be able to play. Permanency pacts formalize that. They actually identify an adult, and they say, Anne, you know Jane. You know that she is going to be going on to college. She's one of our success stories. But we also know that when she comes home from college during break, she has no place to go to. We have never been able to reunify her. Our support for her is expiring. Will you sign an agreement that you will allow her to come live with you during break? So you've known her most of her adolescent life. She can live with you during every break during school. Thanksgiving, Christmas, summer, spring. Anne agrees to do that. We go in case management to 10 people, 15 people. Jane also is going to be needing support to fix her car. Will you agree to help Jane fix her car if it breaks down? Bobby is going into carpentry. He needs tools. Will you sign an agreement? You've known him. He's an extended family member. Will you agree that you will keep him supplied with the carpentry tools he needs to do to go in this trade? These agreements are signed with the young person and the adult saying, I will do this for you. And what we want our jurisdictions to do is to say, this is something we need to think about into age 22, into age 23, into age 25. Long after we're gone, our systems are out of these kids' lives. How have we contemplated more permanency and stability? I don't know about you, but my kids are now 29 and 30. But in their early 20s to mid-20s, they came back a few times and said, there's something I need help with. That's what we need to think about for these kids. And it's not easy. Because of the pathway they followed, because of their backgrounds, there aren't a lot of these people that we easily identify. It takes good case management to identify them. So some jurisdictions use the permanency pacts. I've seen kids' cases with 25 permanency pacts. Small little things that the kid might need, clothing, some types of supports. And in some jurisdictions, they actually bring these people together, as many as possible, into court as their terminating jurisdiction, and they have the permanency pacts executed in open court. These are not legally binding documents. We don't do this because some judge is going to hold someone in contempt for not going ahead and letting them come and live during spring break. But morally, I think it elevates the commitment when I sign the agreement with a young person or when I do it in open court, that I'm more likely to follow through on what I've agreed to do. Okay, this is where we're doing the work. These are our current sites. So you can see we're in about 14 states around the country. with three new counties opening up Ohio that are not listed here, which is Cuyahoga County, Ohio, Stark County, Ohio, and Franklin County, Ohio. What county are you from? Mahoney. Judge Delick. Yeah, phenomenal jurist. So these are the counties that we're working with, and they're implementing the practice model. We are doing a study. We're tracking 1,400 youth that have experienced the practice model to see whether it's changed anything for them. These are some of the results that we're seeing. A 20% increase in early identification of dually involved youth compared to the pre-crossover youth practice model time period. So we're seeing that increase in early identification, the key at the front end of the system. 81% of dually involved youth now being handled using some type of promising practice compared to only 36% of the comparison group. The youth are nearly 3 times more likely to have their cases handled by a multidisciplinary team or a family group conference or a family team meeting. The increased progression of the CYPM sites utilizing a joint assessment process. From the first to the last quarter, there was an increase in use of this kind of assessment process, 25% to 59%, 125% increase. And then a 30% decrease in the use of detention following arrest compared to the pre-CYPM period. And I want to give you a little bit of updated data, but this PowerPoint slide was done actually prior to our most recent report that came out a few weeks ago. And I'll give you a little more data here, 3 bullet points, that the CYPM youth were more likely to have remain at home and less likely to have another planned permanency living arrangement as their permanency plan than pre-CYPM youth and the general child welfare population. So for those of you who are not integrated deeply into child welfare practice, you have to have a plan for a child. And that plan can be reunification. That plan can be another alternative permanency or planned living arrangement. And what we see now is that with the case management elevating to a higher level, more of these young people have as their permanency plan a remain at home or reunify at home as opposed to an alternative living arrangement. And for many of these kids, and I don't want to denigrate that category, but for many of these kids, that is a black hole. That is almost being dropped into the gorge, because it means we're not thinking about the permanency and the adults in that child's life and the living arrangement they should be in to have a family involved in their life. The CYPM youth are more likely to receive diversion than pre-CYPM youth and the general juvenile justice population. So in our CYPM sites, not only were they more likely than the pre-CYPM youth to get diversion, we've elevated the diversion option so high it's used more frequently than the general juvenile justice population. And for juvenile justice folks, the CYPM youth were less likely to have a new arrest 6 months after identification than the pre-CYPM youth. So we're seeing reductions in recidivism as well. This is a publication we released several months ago, back in March 2012. It updates all of the research. You can download a PDF off of our website, which is located at the bottom of this slide. And then at the end of the PowerPoint presentation, and I'm not quite sure how this worked. Was the PowerPoint presentation in the materials that you received? Not? Okay. So I can get the PowerPoint presentation to you, okay? So if you want the PowerPoint presentation, please give me your card, and I will send the PowerPoint to you as well. But this publication is on our website. It updates the research. It lays out the imperatives of our practice model. And then also on our website is a sequencing in a very graphic way of the entire practice model. So that's also available on our website. Okay, we've got about 10 minutes if there are any questions or issues that people identified while I was doing the presentation that you might want to get into. So any questions? Any thoughts? Yes? We have a microphone, so we're going to pass the mic around.
I'm not in the juvenile justice system.
Okay.
But I have some questions, having been a previous school board member and dealing with some of these issues. And one of them is the assumption, the underlying assumption, I believe, of your focus on retaining the child in the home is that the home functions on a certain level.
Right. There would have to be an assessment that serving a child in the home, it's safe, that with services wrapped around that family, we can effectively work with the young person in the family that they're safe and that they have good outcomes. Yes?
Okay, because I've found that many of the family structures are very fragile at best, and that's not necessarily the best place. My other question.
Can I comment a little bit more about that?
Oh, please.
So I think what we need to be doing is looking at, can we keep the child in the family? And I think anyone who works in child welfare would say this is the way we do the work. Can we keep the child in the family with wraparound services? If not, can we find family members that this child could be placed with, again with supportive services? And if not, is there a foster family this child can go to within their school area, right? How do we keep them close to the school area so they don't have to change schools? Okay, go ahead.
And I guess my follow-up question was, any relationship discovered between the crossover incidents and abuse in the congregant placements?
We haven't researched whether we're getting crossover complaints or reverse crossover with maltreatment complaints from the group placement sites. I don't think we have any data on that. Ann did this unbelievable study in Missouri. I don't know if that was any of the factors that you looked at, Ann, in Missouri. Okay.
Potential correlation, I would think. And then my last one is that I found that there was a parental involvement in negative behavior as it relates to the accessibility to benefits for these children who are acting out. Have you done, I don't know if I'm sure you're familiar with it, the behavior disorders that qualify children for SSI checks? No?
I've not seen any research that correlates that with the trust.
I wondered about that because in the school system, we oftentimes found that children were acting out because at a certain level of behavior disorder, they would then be qualified for SSI benefits for the family. And I just wondered if you saw any correlation.
Right.
It accounted to a large extent for the violence in the schools among students and with teachers.
Right. So you're saying with some intentionality, the children were told by their parents, if you act out a certain way, then we may be eligible for some additional benefit.
Absolutely.
Yeah. I don't know if there's been any self-reporting survey or any surveying done on that at all.
I wonder if you, in your research, if you would even consider doing some kind of correlation between the benefits that they're receiving.
Right. Now there was research out of Chapin Hall that looked at kids who left residential facilities in juvenile justice, and the year later where they were. So that was the data I gave you, that a year later 10% were in a child welfare placement. They also looked at kids who went back home, their recidivism levels, and kids who were in the community receiving some type of benefit like TANF. And so the kids who did the best were the kids who went home. The kids who did the second best were the kids who were in a child welfare placement, where there was a more complete range of supportive services. The kids that did worst were the kids who were in the community and receiving some type of social benefit, but not clearly a complete wraparound approach. Any other questions? Any other thoughts? Yes, Cindy.
Yeah, and you mentioned Allegheny County was one of the subjects of some of the research that was done.
Yeah.
So in Allegheny County, which is Pittsburgh, Pennsylvania, for those of you who don't know, we have a dual docket. We have a unified family court system. We have judges who hear these cases where kids are dual involved and adjudicated on the same day. But there have been various indicators to us that our practices are not working, by observation mostly. We don't really have good, hard data on this just yet. But one of the things that we decided to do to try to unpack where we might discover the ways that we might be falling short is looking at homicide rates. So in 2011 in Allegheny County, there were 74 homicides. Of those 74 homicides, 39 involved kids, victims, who were previously involved with our juvenile court. 39 out of 74 homicide victims. Of those 39, 20 of them were dual involved kids. 18 of them were delinquency only, and one, I think, was a CYF only kid. So we're pulling out some of those cases to unpack them and go back and look at case notes, just kind of doing sort of a debrief, a summary. And what occurs to us, at least preliminarily, we're currently in the process of doing this, is that we still have the agency and JPO existing in their own silos, so that even though we have a joint docket, we're not engaging in effective case practices and planning and joint dialogue. I guess my question for you, Shay, is what other things could we look at to try to unpack some of this, right? Because some of these are not so easy to discover because of the way these kids drive into the system.
Well, I think that a lot of the data that we're uncovering in our 1,400 kids at this point is going to better inform exactly what we know about the pathway they follow. The National Council on Crime and Delinquency actually has created a risk tool for crossing over that they're now testing in Los Angeles County that will unpack some of these issues. But I go back to the underlying issue of how do you ensure fidelity? So we have a model, and our model is showing better outcomes for kids. How do you ensure fidelity to doing the model? So, I look at pre-service training, in-service training. I look at personnel evaluations. I look at quality assurance, workforce efficacy issues. I look at bench accountability. The judges having these bench cards saying, are you doing these things? To the level of detail. So I think we're learning more. I mean, to be honest with you, this practice model existed for 3 years. The fact that we have 1,400 kids we can study on what's happening with them informs a lot about what we know. So a county doing work now, today, versus 3 years ago, is much more sophisticated in taking this knowledge and using it. So we launched a site in Hennepin County, Minnesota, Minneapolis. Their elements, their detailed practice elements that are expected of their staff is 3 times as detailed as counties 3 years ago. Because they're learning from the practice elements. So I would go back to that and say, if you're seeing you've got the structure in place, then the question becomes, how are the staff being trained? How are they being held accountable? How are the judges looking at what's expected from these cases? And then quality assurance around that. I mean, it's different. If I say 2 workers need to get together and they chat for 10 minutes and say, well, what do you know about the family? As opposed to, these are the characteristics you need to explore for these crossover families, I think maybe we get to some better outcomes. So twofold answer. Casework, but also continuing to do research on what are the risks associated with crossing over that we could spot earlier in time. And we'll report out on the National Council on Crime and Delinquency as soon as they have results, because they're using one of our sites to test the model. Okay. Yes, Ann.
Well, I started out looking at crossover youth, and it led me to question, why is it that youth cross over? And what is it that's going on in their lives and their behavior that leads them to go from being a victim into a perpetrator? And to some extent, it looks like it's coping. And if you look at why it is they come into the juvenile justice system, it's because they are trying to cope with the maltreatment. They're running away, or maybe they're acting out because they're angry, and so they get in fights, but it's all part of the coping. But the other thing it's led me to look at more is the whole issue of violence exposure. And of course, a youth that's been maltreated has been exposed to violence. And there was a Finkelhor's work, he did a national survey of violence exposure of youth, and what he found was that once a child has been a victim once to violence, either as a victim or even a witness, that they're more likely, 2/3 more likely actually, to be a victim multiple times, which I think kind of feeds into what you're saying, that why you have this high incidence of crossover youth becoming victims of homicide. The fact is that once you've been exposed to violence, it makes you more vulnerable to other violence exposure too. So that's my comment on that.
One of our certificate program that we do, which you were part of, we added a module on trauma-informed care. So this summer, our certificate program now includes that, and it gets into some of the issues that Ann just talked about, the impact of the violence and the impact of the trauma. And in a sense, what our faculty was talking about is that what we've talked about here, what I've called risk factors, in a sense is re-traumatization of many of these young people, building trauma upon trauma. Okay, I think we've run out of time, but thank you all very much. I've got